Guys, I please ask if you limit your testimony to 3 minutes. We do have people and people's time is precious. And just to let everyone know that we do generally take the elected officials out of term because they have other meetings they're attending. I'm also going to be chairing this meeting till about 11 o'clock, and I have another Senate meeting to attend. So Chairman Gordon's going to take over at 11. So I'm going to start the meeting. First up, we have Representative Mindy Dome. Oh, first I'm sorry, Chairman. I'm going to let you introduce the representatives on the line today for us.
Thank you very much, Senator Brady. I appreciate it. I appreciate everybody's attendance today. We've got our miscellaneous docket, which is to say that at the conclusion of this hearing, we'll have heard all of the timely filed bills that were before this committee. And we anticipate we may have another hearing for late files in the new year, but we've now caught up. Thank you to Representative Eiderhoven. Representative Kushmerek is here. Representative Ayers is here. I see Representative DeCoste is here. Let me look through the and see if I've gotten anybody. And some may come in through the course of the hearing, and I'll just welcome them with introduction at that time. But I think those are the committee members, House members who are here right now. Mr. Chairman, you can.
Thank you. And also, after today's hearing, you have approximately a week to submit written testimony after today if you're not able to get all the information in by today. So again, as I mentioned earlier, we generally take elected officials out of order because of their time schedule and other meetings. I don't see Representative Mindy Dome on the line today. Do you see her, Co-Chairman Gordon?
I'm sorry, I was muted. I don't see Representative Dome.
Okay. In the representatives that have signed up, I don't see any of them on the line as of yet.
I see. Let's see. Representative
there's
Gentile.
Representative Gentile. Why don't you start, Representative Gentile? Thank you.
Well, thank you, Chair Brady and Chair Gordon, members of the Joint Committee on Public Service. I'm here in support of my bill, House 2653, Senator Eldridge's bill, Senate 1704, an act relative to death benefits to surviving spouses of call and volunteer firefighters. This legislation would correct errors and omissions from acts of 2014, Chapter 165, Section 73, by amending Chapter 32B, Section 9.5 of the general laws. In doing so, it would provide a local option that would have to be approved at town meeting or city council, which would improve some death benefits for survivors of on-call or volunteer firefighters who perish in the line of duty. The Commonwealth relies on call and volunteer firefighters to protect property and life. In doing their job, they risk their own lives to protect communities. When those who serve the Commonwealth are killed in the line of duty, the community has an obligation to care for them and their family in return. This bill would help these families in 3 ways. It would require the municipality where the officer served to charge the surviving spouse the retiree rate instead of 100% of the premium for health insurance. It would remove the words "continue to," allowing the surviving spouse and children to participate in the insurance, regardless of whether they were participants at the time of the officer's death. And finally, it would allow children over the age of 19 who are physically or mentally incapacitated to stay on the fallen officer's insurance. These families deserve robust death benefits, but offering such benefits also helps the Commonwealth. When going into a dangerous line of work, any reasonable person's first thought is whether their loved ones would be cared for in the worst case scenario. At a time when labor is in short supply, such benefits attract qualified individuals to work as firefighters and help retain those that are already in these roles. There's no financial cost to the Commonwealth, and the legislation is endorsed by the Massachusetts Call Volunteer Firefighters Association. I want to thank you again for the opportunity to testify and for considering my request that the committee favorably report an act relative to death benefits to surviving spouses of call and volunteer firefighters. Happy to answer any questions the committee has about the bill. Thank you.
Thank you, Representative. I don't have any questions. My co-chair, Rep. Gordon, Mr. Chairman, do you have any questions?
No, thank you for that very complete testimony. So you really answered the questions that I had looking at the bill. Thank you very much.
Anyone else from the committee have any questions? Seeing none, thank you, Representative Gentile. Next, I see Rep. Haggerty, Representative.
Thank you, Mr. Chairman. I'm going to wait. I have one more person I'm waiting on, and Representative Tucker, he should be with us very shortly. If you
Okay,
wouldn't mind.
when he comes on, we'll look for him as well. I don't see any of the other reps on yet, so we're gonna go to Sean Duhamel. The Mass Retirees, Sean? Are you muted, Sean?
Morning, Mr. Chairman. Can you hear me?
Yes, we can hear you loud and clear now.
Thank you. I had to switch computers. It wasn't, I unplugged myself. Thank you for the opportunity. I apologize for the technical glitch on my end. For the record, I'm Sean Duhamel, Chief Executive Officer of the Mass Retirees Association. We have two bills before you this morning, both related to retiree health insurance benefits, one being at the local level, the second being at the state level. We have two bills that would apply to local retirees, filed by Representative Day as well as Senator Feeney. It's House 2613 as well as Senate 1712. And these two bills, Mr. Chairman, would cap the premium contribution rates of retirees that exist at the time they retire. So in other words, if you retired from the city of Brockton and you retired at 75-25, that contribution split would remain in place for the duration of your retirement. It couldn't be changed on you. And this is the same policy that the Commonwealth itself has implemented for its retirees since the early 1990s. At this point in time, the Commonwealth has three different levels of premium contribution rates for retirees that are based on the time or the date that someone retired. So in other words, we're not changing the rules on retirees. We're not pulling the carpet out from under anyone. If the cities and towns want to change retiree contribution rates for the future, they are certainly allowed to do so. Again, this would just cap those rates for existing retirees, that we're not changing the rules on anyone. The second bill, Mr. Chairman, House 1281, filed by the House Republican leader, Representative Jones, is legislation that would require the States Group Insurance Commission to buy in Medicare eligibility for the 10,000 or so non-Medicare retirees that are insured under the GIC. As you might know, public employees here in Massachusetts up until April of 1986 did not participate in Medicare. Anyone hired from April 1st of 86 forward into the future participates in Medicare, not under Social Security, but participates in Medicare. They themselves, as well as the public employer, pay into the Medicare system, gaining eligibility. However, for anyone entering public service here in Massachusetts prior to April of 1986, they did not pay into Medicare. So unless they had worked in the private sector or have gained Medicare eligibility through a spouse, they are not eligible for the federal Medicare program. They're still eligible for retiree health insurance. However, those health insurance benefits are part of the same plans that the active employees have access to and are members of, and they're fantastic quality plans. The problem is they're expensive. And as someone ages, it becomes more and more expensive for them. So there is a federal program that allows cities and towns, as well as the Commonwealth, to buy into the program. Over the past 5 years, we've had about 30 municipalities do this with great success. It's been a win-win across the board. We are working with the state GIC to implement this without the need for legislation. Representative Jones filed this bill as more or less a placeholder in case a statutory change is needed to move forward. But we believe if the Commonwealth were to implement this, there would be tremendous cost savings for both retirees as well as the taxpayers in the tune of tens of millions of dollars a year. So, Mr. Chairman, I know my time is up. Thank you very much for the opportunity. I'm happy to answer any questions.
Thank you, Mr. CEO Duhamel. I don't have any questions. Thank you for your testimony. My co-chair Gordon?
No, but are you testifying with Nancy McGovern and Frank Valeri?
It's just myself this morning, Mr. Chairman. I'm sorry for the confusion. We
No,
tried to
that's okay.
streamline it and keep it moving.
Thank you, Sean. Thank you, Mr. Duhamel. Thank you very much for your testimony.
Anyone else on the committee have any questions? Seeing none, thank you, Sean, for your testimony. Next, we have Rep. Erica Uderhoven, Representative.
I believe, Mr. Chairman, that the representative is sending written testimony.
Okay,
And also, I point out that we have Judge Mashera on the line. I know that he's got a crowded courtroom.
right. We were going to take him next, so go right ahead, Judge.
Judge Mashera,
Your
you're
Honor, I
muted.
don't know if you're muted.
You would think by now that I would have this done on the Zoom. Chairman Brady, Chairman Gordon, thank you so much. And members of the Joint Committee of Public Service. My name is Matthew Mashera. I am currently the first justice of the Chelsea District Court, currently serving in my 9th year. I spent 10 years as Assistant District Attorney in Suffolk County and then 10 years as a bar advocate where I ran my own practice in Chelsea. And today I'm here to testify as the president of the Mass Judges Conference. The Mass Judges Conference is a not-for-profit professional association. We get support from almost 90% of the Commonwealth's judges. Specifically, I offer testimony in support of H 2741. The MJC offers this legislation in the context of the Mass Judges Conference legislative priorities that impact veterans serving the judicial branch, cost of living adjustments for retired judges, judges' access to equitable pension survivor options, which was offered by the Office of the State Treasurer, judicial and court security, technology, infrastructure, and fair and equitable judicial compensation. H 2741's primary purpose is to retain senior and experienced judges at a time when their experience is a critical and indispensable asset of the trial and appellate courts. This is especially important as we start to work our way to address the heavy caseloads that grew out of the changing infrastructure from the COVID situation that has affected us all. Now, under the current rules, judges with at least 15 years of judicial service and reaching the age of 65, should they opt to retire, can receive their full pension benefits. A $5,000 compensation supplement to a qualified judge's base salary is intended to provide a judge with an incentive to continue with their judicial service to the age of 70, the mandatory retirement age. Well, this supplement will not increase the judge's long-term pension benefit or survivor benefit. It will reduce the loss in pension income should a judge continue until age 70. It's important to note that a judge's pension is generally reduced the longer they remain on the bench after age 65. This is also important because Massachusetts cost of living reduces the purchasing value of every dollar by 25%. Finally, as new judges evaluate the long-term options, this is a promising addition to the benefits the Commonwealth can offer judges who make a long-term commitment to judicial service. Thank you so much for your time and consideration. I welcome any questions or comments.
Thank you, Your Honor. I just have a question on a generic note. How are things, because of COVID, when everything was shut down, are things, in your estimation or your opinion, are things starting to get caught up with the court systems, or are they still overburdened and behind?
I'm proud to say, due to the great leadership of our trial court, our courts were only closed for 2 days. Other than that, we've been running at about 75 to 80% capacity. A lot of the backlogs are trials. And what I'm really encouraged about is the amount of jurors that we're getting on a daily basis is higher than it was before COVID, believe it or not. So we have a huge backlog of trial cases to work through. And I'm happy to say that since the jurors have started on September 7th, we've seen a lot of trials, a lot of backlog is starting to dissipate. And the participation of the members of the public to do their jury service has been excellent.
Thank you, Your Honor. Mr. Chairman?
I really don't have a question, but thank you for providing this important testimony. I'm sure that your docket is crowded. today, and you took the time to be with us, and that's important. And thank you for doing that.
I appreciate all the work that you guys do, and I really appreciate the time that you continue to give to judicial branch. Thank you so much.
Thank you, Your Honor. And we appreciate all the work that's been done in the court in light of what's happened with the COVID. I know a lot of the hearings were done virtually in the beginning of the whole situation. So anyone on the committee have any questions? Seeing none, thank you, Your Honor, for your testimony.
Thank you so much. Have a great day, everybody.
So until we see some of the other elected officials coming on, we're going to go to Charles Goodwin.
Good morning, Mr. Chairman. Thank you for allowing me to speak today. I will make it brief. I'm speaking here today on House Bill 2781, which is entitled an act to provide public safety telecommunicators with the same internal benefits as first responders. And this bill, very much something that I'm passionate about. The purpose of this bill is to recognize those public safety 911 telecommunicators in the state for the work that they prominently do. Currently, those telecommunicators are classified as administrative or clerical, but we're working to recognize them as true first responders. Those same 911 public safety telecommunicators are those that answer the 911 phones and are the first contact with every person during an emergency. They're responsible for much more than that, however. They're also responsible for maintaining contact with police and fire emergency responders, ensuring that those responders remain safe, gathering and collecting, analyzing and recording information, providing emergency medical dispatch instructions to callers to help provide medical aid until ambulances arrive on scene, and many, many more responsibilities. So as you can see, that this role is much more than just being clerical or part of an administrative type role. They are a true first responder. The purpose, or what I should say, the benefit behind this bill is not one of money or anything else. It is simply one, to recognize them for the work that they truly do, and two, to provide some of those same internal benefits like access to PTSD and stress counseling and some of the other internal benefits that police and fire get after major critical incidents that some agencies may not offer, or this position may not get currently based off its current classification in the state. These public safety telecommunicators work day in and day out, 24 hours a day, 7 days a week, to include, coming to work during some of the worst disasters, and even working, throughout COVID, 24 hours a day, coming in and making sure that there was always somebody there to maintain and answer those 911 calls. So I ask for your consideration today, as well as the rest of the committee, to look favorably upon this bill and to finally recognize the 911 telecommunicators in the Commonwealth of Massachusetts as true first responders. Thank you.
Thank you, Mr. Goodwin. I know that they've been on the front line during this whole pandemic as well, like everyone else. I don't have any questions. Chairman Gordon?
No, but thank you for the points that you raised, and thank you for the work that you do.
Thank you very much.
Anyone else on the committee have any questions? Seeing none, thank you for your testimony. Next, we're going to Susan Bauer. Susan Bauer on? We can get back to her. What about Sean Dewey? I see Sean's name on the thing there. Thank you, Sean.
Chairman Brady, Chairman Gordon, and other honorable members of the Joint Committee on Public Service, I thank you for the opportunity to allow me to testify before you today in support of House Bill 2554 and Senate Bill 1689. My name is Sean Dewey, and I'm employed with the New England Police Benevolent Association, where I serve as the Director of Massachusetts Corrections. The NEPBA represents corrections, police, and support personnel throughout Massachusetts. That includes correction officers and supervisors, as well as support staff in Middlesex County, Worcester County, Norfolk County, Plymouth County, and the Massachusetts Department of Correction captains. My previous employment began in 1983 as a correction officer with the Mass DOC, where I rose through the ranks and retired earlier this year at the rank of captain. During those 38 years employed by the Department of Correction, I spent 22 years at the state's maximum security prison in Shirley, Sousa Baranowski Correctional Center. I also served more than 20 years as an executive board member of the Captains Union, where I had the opportunity to routinely interact with county correction officer union officials regarding all aspects of correctional work. In my capacity at NEPBA, I have union oversight and constant communication with correctional and support staff in Middlesex, Worcester, Norfolk, and Plymouth counties. I attend contract negotiations in all of those counties with the respective sheriff's departments, where we negotiate job duties, working conditions, benefits, and salaries of correctional personnel. As members of this committee are likely already aware, the salary increases of all of these counties are set at the same percentage increase by the state that all counties across the Commonwealth are restricted to. Despite the fact that all county correction officers perform the same duties, the current salaries vary widely in the 14 counties. The base salaries among county correction officers with no supervisory rank and similarly situated range as much as $15,000 annually from one county to another, and as much as $20,000 annually compared to state correction officers. With the state restricting every county to give the same salary percentage increase, if you're currently the lowest paid county, you will always remain the lowest paid county. The reason I'm here today is to impress upon you that county and state correction officers all perform the same job function and should be compensated the same. State correction officers work at various facilities across the Commonwealth and all make the same salary, regardless of which county they reside in. Yet the salary of their neighbor, who is a county correction officer, varies widely. House Bill 2554 and Senate Bill 1689 will establish correction officer pay parity among state and county correction officers. We ask that you report these bills out favorably. Thank you for your attention and consideration of this testimony, and I'm willing to answer any questions the members of this committee may have.
Thank you for your testimony. I do have a question. How long has this disparity between counties been going on? Do you know off the top of your head roughly? Has it been going on for quite some time, I understand?
I think for many, many years, the disparities have been there. Up until the point, I believe it was 2009, when the counties came into the state system, various sheriffs had the opportunity during contract negotiations to, increase salaries based upon what other counties were making across the state. But as of now, when we go to the table, we discuss salaries, but as everyone knows, they're set at the same rate across the state, and there really is no ability at the local level for organizations like ours to be able to increase, a particular county that may be deficient compared to other counties.
Thank you. Thank you for your testimony. Chairman Gordon?
Yeah, just really one question. Do you have information about essentially the ratio of officer to the people that you oversee? Does that vary widely county to county, as far as the number of officers per the number of people assigned there?
I'm not sure, Representative Gordon, what it is you're asking me. Could you repeat that?
Yeah, I'm asking you if the number of officers varies depending on the size of the facility. I would think it does.
Oh, it absolutely does. The
Yeah.
size of the facility and the makeup of the facility, would determine staffing. How many inmates are in a particular block would determine how many officers would have to be assigned to that block. The amount of correction officers from county to county obviously varies depending on, the number of the inmate population.
Right. So that's my question is, does it vary if we're comparing an officer overseeing a certain number of inmates in one county to another? Is that at all consistent, or is that completely inconsistent? In other words, if you have 20 assigned to an officer, would that officer in one county be paid significantly more than in another county?
I don't think the rate of what they're paid in the county equates to how big that county is or the amount of inmates. I think it's just been all over the map for many years. Essentially the pay in between the ranks is essentially about 10%. That's really been the standard across the state, where, the rate between a correction officer 1 and a correction officer 2 would be 10%. And that varies from county to county as well. So that's what we're trying to establish is consistency across the state, where, again, they all perform the same duties. And that's, what I've testified to here today is, I worked 38 years in the state system, but I've had many years of experience with the county systems and what they do. And that's my message here today, is that county correction officers and state correction officers really perform the same function.
All right, thank you.
Thank you.
Thank you, Mr. Co-Chair. Does anyone else have any questions on the committee? Seeing none, thank you for your testimony, sir. I see Rep. Tucker has joined us, so Rep. Hagerty and Representative Tucker, do you want to go forward?
Thanks so much, Mr. Chairman. Thank you to yourself and Chair Gordon, of course, along with the rest of the committee, for allowing me to speak in front of you today on behalf of H2669, an act to exempt the executive director of the Municipal Police Training Committee from earnings, which I filed jointly with Representative, of course, Paul Tucker. As stated, this bill would exempt the position of executive director of the Municipal Police Training Committee from the earnings limitations under Section 91 of Chapter 32. The bill would allow an employee retired from the Commonwealth or from any county, city, town, district, or authority the opportunity to serve in this capacity and be fully compensated. At the moment, several other positions are currently exempt from earnings limitations, including chief justices, associate justices, and several others. I appreciate the positive steps the legislature took just a few weeks ago in expanding the number of working hours retirees can work from 960 up to 1,200. Unfortunately, that positive step does not address this specific issue. Due to a state emergency the past 2 years, the current executive director has been exempt from the earnings limitations. Massachusetts has some of the best trained and well-educated public safety officials in the country, and the current law essentially exempts public retirees from serving in this role because they can only be compensated what would be considered 30 weeks at this point. The executive director is a vital asset to the Municipal Police Training Committee, and allowing the committee the opportunity to hire someone full-time who was a retired public safety official from Massachusetts just makes good sense. If the executive director of the Municipal Police Training Committee is to be exempt from the earnings limitations, the entire Commonwealth may benefit from the years of knowledge and expertise in these areas. Thank you again for the opportunity, and I'd like to hand it over to my colleague, Representative Tucker, who I might add is a well-respected and former police chief here in the Commonwealth. Thank you.
Thank you, Rep. Hagerty, and good morning, Chair Brady and Chair Gordon. It's good to see both of you, and thank you for recognizing both of us to be able to speak on behalf of this bill, which would exempt the executive director of MPTC training from the earnings limitation. As we all know, we've seen tremendous spotlights on policing, along with a number of reforms that our legislature has enacted over the last couple of terms. In such an extraordinary time, the training of law enforcement officers has taken on even more of utmost importance. I believe that the excellent work of the Mass Police Training Council would be enhanced and benefit by casting the widest net possible for a director, but in a way that's not currently allowed by Massachusetts law. While the proverbial nationwide search may and should be done, what should not be done is ignore the homegrown, talented law enforcement executives who are currently precluded from applying after being leaders in their own departments due to the salary limitations and the effect on their pension. This bill would create the exemption from current Mass law and allow the opportunity for a trusted, proven leader to apply to oversee this training. This is not for any one specific person. This, to me, is casting the widest net possible for this critical position. As Rep. Haggerty said, this is not without precedent. I would add that school superintendents also fall within these parameters as well. So rather than have just out-of-state applicants who may or may not be as well qualified, why wouldn't we expand the pool and try to give somebody the opportunity who has that familiarity with Massachusetts law? One of the previous directors came to us from the state of Wyoming. He was a terrific guy, did what I consider to be an admirable job. But when we preclude or exclude Massachusetts trained law enforcement executives, I think that we can do better and at least provide the opportunity, and then we'll see who the best director would be. I think this is a good bill, and I urge favorable passage.
Thank you to both representatives. I don't have any questions. Do you, my co-chairman Gordon?
No, Chair Brady, we've been working on this bill and we'll continue to be looking at it. Thank you very much for your testimony.
Anyone else from the committee have any questions? Seeing none, again, thank you both for your testimony.
Thank you all.
Thank you, Mr. Chairman.
Next, we're going to Representative Mindy Dome.
Good morning. Thank you so much. It's wonderful to see everybody. I hope we get a chance to see each other in person soon. I'm Mindy Dom. I'm the state rep for the 3rd Hampshire District. I represent the towns of Amherst, Pelham, and Precinct 1 in Granby. And I thank you for today's hearing on H4170, a bill that would mandate the review of climate risk as an economic risk for the purpose of protecting public pension beneficiaries, taxpayers, and our planet. And I greatly appreciate being taken out of turn and being given this opportunity to sort of give you a summary of the bill and also be available today, obviously, for questions and after today's hearing as well. I'm thrilled that we're hearing this bill the day after a historic infrastructure bill has been signed by President Biden. My understanding of the infrastructure bill is that it reflects in part our nation's need to move forward with reducing our reliance on fossil fuels, whether it's in the transportation sector or the construction sector or upgrading the electrical grid. The bill offers an incredible opportunity for our state to move away from fossil fuels and support this legislature's goals. But we've already done that. This session earlier, we passed historic climate legislation that also included changes and transformation in those sectors. And this bill is compatible and aligns with our legislation. The bill before us today is necessary because it does the following things. 1, it defines climate risk as an economic risk. 2, it aligns our public pension investments with our historic climate bill, putting our investment practices on a roadmap that supports our climate goals and also reflects our aspirations for success. It advances the roadmap legislation by potentially freeing up funds that can be reinvested in renewable energy and net zero technologies. It protects our state's pension funds from the declines that we're already starting to see in the fossil fuel industry. And it ensures retirement security for more than 300,000 Massachusetts pensioners by steering our investments away from the volatile, declining, and hopefully ultimately failing fossil fuel industry. According to the Treasurer's Office, the Commonwealth has approximately $90 billion in our state pension funds. These monies are invested in a range of industries, including fossil fuels. To meet our climate goals, the Commonwealth is undertaking a historic transition, decarbonizing our energy use and our energy production. Decarbonizing our public pension funds will not only safeguard public retirements from the impact of this transition, but will also free up additional funds for investing in our new, clean, renewable energy future, including the research and development and manufacturing necessary to make us leaders in wind energy and battery storage technology, public transit and rail, retrofitting homes and municipal buildings, changing the way we heat and cool buildings, and the list goes on. Our future will depend on the development of these initiatives, and that will take necessary funds. Some of these funds can be recovered through decarbonizing our stock investments and transferring these funds into these new prioritized industries. Decarbonization allows funds to be shifted just as our state and federal policy is shifting towards investments in renewable energy. And if I may, I just want to call out a couple of special features included in this bill for your consideration. H4170 would do so by establishing a climate risk investment review committee charged with studying, identifying, and reviewing the climate risk investments that exist currently in the public fund. It would require the committee to develop a plan to sell, redeem, divest, or withdraw from climate risk investments that pose economic risks and are not aligned with the Commonwealth's climate goals. It sets a deadline for implementation, no later than 2025, to support timelines that are established by the legislature. It maintains a public list, updating it quarterly, of climate risk investments. One of my favorite parts is it encourages asset managers who are engaged with the Retirement Review Board to create fossil-free offerings, so that if we have some investments that are tied up in fossil fuel industries, but they're jumbled into a big fund and they can't separate them, it requires the committee to in fact request a fossil-free fund that could then be used in its place. It gives cities, towns, and the public access to reports and materials created by the Climate Risk Investment Review Committee for their own decision-making purposes. Research has shown that investments in the clean energy sector are compatible with successful and sustained economic growth. H4170 aligns the Commonwealth's public pension investments with our goals to diminish the use of fossil fuels, protect our pension funds from industries that adversely impact our climate and economy, and our national and statewide efforts to decarbonize our energy use and our economy. If and when we are successful, our policy will result in decreased fossil fuel use and a reduction in fossil fuel emissions. It's time to move our money out of these companies. Decarbonizing our pension funds makes our investments reflect our climate
I'm
goals.
sorry to interrupt you, but I think we're well over the 3 minutes that.
I'm sorry, thank you. If I may just close and say just one more point, if I may. For some young employees right now who are just starting to pay into their pension funds, aligning where we invest with their climate goals is critically important. And I respectfully request a favorable report for H4170 and to advance it. Thank you, and I apologize for going over my time.
Thank you, Representative Chairman Gordon. Do you have any questions?
Yeah, Rep, do you know how much we have invested in fossil fuels?
No, that's part of what this committee would do, sir, is this committee would review our current investments and identify exactly what and where and how much is invested in fossil fuels.
Okay, so we don't know how much is invested in
Not at this
renewable
point.
energy, no, renewable energy either.
Right.
Okay, all right, thank you.
Thank you, Mr. Co-Chair. Anyone else on the committee have any questions? Seeing none, thank you. Thank you, Representative. And again, with everyone's patience, if we can do our best to limit to 3 minutes. We have a lot of people to testify today. And as we all know, everyone's time is very valuable.
Thank you. I apologize.
That's okay. Thank you, Representative. Representative Consalvo?
Good morning, Mr. Chairman. To both chairs, thank you for the opportunity to be here today. I'm here to testify in favor of House number 4233 and urge a favorable report. This is a home rule petition from the city of Boston to grant a waiver to Daniel Flores to allow him to continue in the process to become a Boston police officer. This was supported enthusiastically by the Boston City Council, which passed it unanimously, signed by the mayor, supported by the administration. And this does not guarantee that Mr. Flores will become a Boston police officer. It just allows him to continue to participate in the process. As you know, or maybe aware, you can't be older than 40 years old to be in the process to become a Boston police officer. He is currently in the middle of that process, and he has turned 40, and he is over by 3 months. And so as a result, it will disqualify him. So we're asking with enthusiastic support of the city that he just be allowed to continue the process and let the process take its course and see whether or not he is fit to be a Boston police officer. I would just add that he's formerly a Boston school police officer, now a school resource officer, has worked previously with Youth Options Unlimited for over 11 years, working with youth between the ages of 16 and 24 in our city, and seen, obviously, due to his resume, qualify for the position, but does have to follow the process. And we want to let the Boston Police vet him thoroughly and give him that opportunity to be vetted thoroughly by the Boston Police Department. We ask for your favorable report on this, and you will hear from Council Arroyo and others, either through written testimony or verbal testimony later. Thank you.
Thank you, Representative, and congratulations to all the newly elected mayors and city council across Commonwealth that got recently elected. Chairman Gordon,
I have no questions. Thank you.
thank you. Anyone else from the committee? Saying none, thank you. And we appreciate, in the essence of time, as well as the written testimony that we'll be receiving shortly. Next, I'm going to Sue Stafford.
Hello, my name is Sue Stafford, and I'm a member of Mothers Out Front. I live in Cambridge. Thank you for the opportunity to speak in support of H 4170, an act to mandate the review of climate risk in order to protect public pension beneficiaries and taxpayers. This bill, as you know now, mandates the decarbonization of our public pension fund. I know that similar bills have come before the legislature for years, only to be rejected. This time is different, and this bill is different. This time is different. The International Energy Agency stated in its recent net zero by 2050 roadmap that achieving the world's climate goals requires no new coal, oil, and gas developments and triple the amount of investment in renewable energy projects by 2030. The times have changed, and we must change too. The situation is increasingly urgent. This bill is different. First, it aligns the decarbonization of our public pension fund with a historic climate legislation passed last year, and I thank you all for supporting that legislation. It makes sense that our public pension investments be consistent with the climate goals of the Commonwealth, and H 4170 accomplishes just that. Second, it's a bill focused on finance, and the financial argument is now strong. Fossil fuel investments are bad investments. Over the last 9 years, fossil fuel stocks have routinely underperformed the market. These long-term trends are significant, especially for pension funds that must pay out over long periods of time. Our approximately $90 billion pension fund has about 8% of its portfolio invested in fossil fuels. Does that make financial sense? I think the answer is no. As a taxpayer, I don't want to foot the bill for pension fund losses, and I bet you don't either. Third, and please note this significant feature, the bill encourages the asset managers engaged by the fund, for example, BlackRock, to create fossil fuel offerings. The mandate is not a blunt hatchet job, but more like a surgical removal with options. With a legal mandate from the legislature to decarbonize, the fund can put pressure on the likes of BlackRock to offer more options consistent with that mandate, saying, in essence, I don't want to pull my money out of BlackRock, but you have to give me more options that I can legally invest in. The result of shifting capital in this way will be good for pensioners, for taxpayers, and for the planet. I'm pretty sure that includes all of us. I urge you to vote this bill favorably out of this committee. Thank you very much.
Thank you, Ms. Stafford, for your testimony. Chairman Gordon,
I don't have any questions. Thank you.
anyone else from the committee have any questions? Seeing none, thank you for your testimony.
Thank you.
Next, I see Dan Shea.
Hello. Am I
Go
good?
right ahead, sir.
All right, thank you. I just wanted to start by thanking the committee for giving me the time to speak today on behalf of County Corrections, specifically HB 2554, 2568, and SB 1689 and 1752. been in corrections for 17 years. Currently serve on the executive board for the NEPBA, representing upwards of 1,500 officers from Plymouth, Worcester, Norfolk, Middlesex. So as a Middlesex officer, we're obviously not, we're a bigger county, we're not in that lower half of the compensation scale. So I'm not here for myself personally today. I'm speaking on behalf of the individuals we represent. Whether it's been the NEPBA attending rallies or personally attending MACO meetings, we've always understood, supported, what these bills have represented as far as pay parity. As an officer since 2005 and union representative since 2008, I've had the opportunity to meet with corrections officers from other counties and the DOC. In my tenure, I've also worked and toured other facilities outside of just Middlesex. Everything considered, I can say confidently that there is no discernible differences between county and state officer when considering the institutions they report to, the incarcerated clientele they have to serve, the job duties they perform, and most importantly, the communities they keep safe. I've also had enough personal dealings with both county and state officers to know that it's not just the responsibilities and job duties that are interchangeable, but unfortunately also the most difficult parts of being in corrections are also transitive. Physical harm, mental anguish, family stress, long undesirable hours, life expectancy, just to name a few. The last 20 months during the pandemic, we've seen an instinctual unification in law enforcement, pure acknowledgement and respect for each other, and recognition that we have all been through the same hardships and taken the same risks for our families and communities. As a result, this unfortunate time has only magnified our similarities and the need for this bill. In totality, my experience has shown me the only disparity from officer to another is the compensation they receive. It's arbitrarily delineated on whether they're considered county or state. In conclusion, I spoke here today that not only do we keep the duties, responsibilities, and expectations equivalent for state and county, but you see favorably upon HB 2554, 2568, and SB 1689 and 1752 to ensure this pay is comparable. Thank you.
Thank you for your testimony, Chairman Gordon.
No questions. Thank you very much for your testimony.
If I could say one more thing, Chairman Gordon, I was on listening when you were speaking with Sean Dewey on these similar bills.
Yep.
And I think the question that you were trying to get through to him was whether or not, you know, there was any consistency with the size of these counties in comparison with the kind or the amount of clientele that you deal with on a daily basis.
Correct.
I think that's where the comparative nature of your question was going. And I think the best way to describe it is whether or not you have, 450 officers in Middlesex like we do, or 100 officers in Barnstable County. The job is the same. I could walk into a unit in Middlesex and be in charge of 50 inmates, same as an officer in Barnstable. So the amount of inmates that you have to watch, no matter how big your county is, it certainly can be comparable. No matter the size of your staffing or the inmates.
Thank you for answering that, because you're right. It is what I wanted to know, if it was just willy-nilly or if this was the case that you're.
I appreciate your time. Thank you.
That's what I wanted. Thank you.
Thank you. Does anyone else have any questions on the committee? Seeing none, thank you, Dan, for your testimony. Next up, we have Susan Redditch.
Good morning. My name is Susan Redlick, and I'm from Cambridge, Massachusetts, also a member of 350 Massachusetts. I would like to recommend a few additional points in support of H4170 that Representative Dom so compellingly described. First of all, this is a changing financial climate, and we need to weatherize our pension fund. As Representative Dom explained how that would take place with a review committee.
And further, as you read the bill, you will see that it has several provisions for accountability and transparency. This is what really appeals to me, because we will be able to see as the work goes on with this committee, which, by the way, is made up of many stakeholders and experts, independent experts, and some elected officials. This mix of experience and expertise is important because the pension fund needs to be resilient over the long term, as we know. And it will be faced with many kinds of carbon related risks as investments are examined. So the accountability part is really where we can see the results, the transactions that are recommended by this review committee. There will be a website, there will be materials available to the public and to any of the legislators to see on what basis the decisions are made to recommend changes in the investment portfolio. There is an additional benefit for those of you representing districts with local retirement systems not under the control of PRIM. These boards will be able to request the kind of information that's being developed by this review committee and look at the information, and it would help them in making decisions about their own portfolios. There will be published findings of the review committee, and so you may not realize that there are there's $86 billion in combined assets in these several hundred independent municipal and county retirement systems. Finally, fiduciary duty is changing in this era of climate emergency. Beavis Longstreth, who is a retired lawyer and former commissioner of the United States Securities and Exchange Commission, said the following, and I quote him: "For fiduciaries, the planet's present condition and trajectory pose major and growing portfolio risks. Prudence requires that they be well informed about these risks and act with the requisite caution and care." End quote. H4170 responds to this principle of caution and care for calling for a reevaluation of our pension fund investments. Thank you for letting me testify.
Thank you for your testimony, and I had to put my glasses on because I missed the L in your name, so I apologize if I mispronounce your last name. Chairman Gordon?
No, I don't have questions. Thank you.
Thank you. Anyone else from the committee? Seeing none, thank you again for your testimony. Next, we have Paul Jakes, Craig Hardy, and Mark Sanders.
Good morning, Chairman Brady, Chairman Gordon, members of the committee and staff. Thank you for the opportunity to testify today. For the record, my name is Paul Jakes, legislative agent for the Professional Firefighters of Massachusetts, joined by Craig Hardy, legislative agent, Professional Firefighters of Massachusetts, and Mark Sanders, Boston Firefighters Local 718, legislative agent. In the interest of time, we have submitted written testimony and just wanted to go on to the record in support of Senate Bill 1743, an act relative to firefighter training. Like I said, we have submitted written testimony, and I will be the only one testifying today, but we want to ask you to report this out favorably from committee. Thank you.
Thank you. Thank you for your testimony and the written testimony. Chairman Gordon?
Thank you very much. Although I don't have questions right now, I am interested in any continued dialogue about this bill. So thank you very much for your availability.
Absolutely, anytime. Thank you.
Thank you.
Thank you. Anyone else from the committee? Seeing none, thank you, gentlemen. I'm going to be putting the reins over to Chairman Gordon. I have another meeting in the Senate to attend, but I'll be coming back. So Chairman Gordon's going to take over from here, and I think Darcy Dumont is up next.
Thank you, Chair Brady.
Thank you, Mr. Chairman.
Darcy, are you here? I don't see you in the line, in the participant line. So I'll go to David Backer. David Backer, are you here? Let's see. I do see you here.
Good morning. My name is David Backer from the 11th Middlesex District. Thank you for the opportunity to speak about H4170. I'll be brief. I've been a Massachusetts resident, a voter, and a taxpayer since Francis Sargent was governor of the Commonwealth, who, by the way, was known as an environmentalist.
David, I'm going to ask you a question, even though
Yes.
I'm one of the few state reps that, rather than the 11th Middlesex, can you tell the folks watching what municipality do you live in?
Oh, sure. I'm in Newtonville, which is part of Newton.
Okay, go ahead. I just wanted to.
No, that's fine. Thank you.
Okay, thank you.
So I strongly support 4170 because at its core, it protects public pension beneficiaries and taxpayers. I'm not only a taxpayer, I also have funds in the city pension fund. The U.S. Department of Labor put forward a proposed rule that would remove current obstacles preventing U.S. workplace pension schemes from considering so-called environmental, social, and governance issues, or ESG, when investing, including using ESG funds for their default strategies. And as we've heard, a number of credible reports have tracked investments in fossil fuels over the last decade. Some of those have underperformed the market, and more to the point, some have lost value, and any public funds, such as pension investments in those funds, would therefore have lost some of their value. Even Larry Fink, chief executive of BlackRock, the world's largest asset manager, has said climate risk is investment risk. So H4170 creates a committee of knowledgeable stakeholders to meet regularly and take into account the climate risk investments have financial risks to pension beneficiaries and the Commonwealth's taxpayers. And it provides a process for pension funds to get out of those investments that are not aligned with the Commonwealth's stated climate goals, and even request fossil fuel-free alternatives. If pension funds lose value, it appears that the taxpayers will be on the hook to cover the losses. And this applies to almost 8% of the 90 billion, that's with a B, billion-dollar fund. And if the investments are contributing to the climate crisis, they are clearly undermining the Commonwealth's stated goals. I personally care about what my money is being invested in. And I care that my contributions to my pension fund will increase in value without destroying the climate. I urge you to support H4170, and I will be following your decisions very closely. Thank you very much for the time.
Thank you very much, and I expect you will be following our decision. But I do appreciate your focus on the financial impact of the bill and the analysis and focus that you had. So thank you for that. Anybody from the committee have any questions? Seeing none, thank you for your testimony. We've been joined, in fact, we were joined quite some time ago by Vice Chair Higgins. And with that, I'm going to call on Bridget Quinn.
Hi, good morning, Chairman Gordon, Vice Chair Higgins, and I think we still see Chairman Brady there, and members of the committee. My name is Bridget Quinn, and I'm the Legislative Director for the Mass AFL-CIO. And I wanted to give you brief testimony this morning on a few bills. The first one is House 1295, which would limit it out-of-pocket expenses for the subscribers to the GIC. It would limit it to $2,500 for individuals and $5,000 for families. I'm sure we know one of the most certain things we know is that healthcare costs rise every year. And so with many state employees already contributing, upwards of 25% for their premium share, which translates to about $700 a month. Additional costs, for health insurance or, things that aren't covered can be really provide a financial hardship for families, especially with, we know people are paying student loans, rent, mortgage, daycare costs. So we'd like to really bring those costs down to make it more manageable for our state and municipal employees. I would also like to testify in favor of House Bill 2722, an act establishing fairness in GIC premium contributions. This would put all state employees at an 80-20 split. I briefly wanted to mention Senate Bill 1167, which my colleague Jim Durkin will tell you about shortly. And I just want to mention two other bills, Senate Bill 1687 and House 2554, which would establish pay parity for county correctional officers. My father is a retired correctional officer from Worcester County, and he worked there for 35 years, working, his butt off, as we all know our COs do. And, the functional work is absolutely the same. The care, custody and control of incarcerated individuals. And also the risks are the same. The risks for, stress-related illness, the risk for PTSD, the risk certainly for injury, and any sort of work-related illnesses later on, maybe even after they retire, are the same. So I urge you to report all these bills out favorably from the committee. Thank you so much.
Thank you very much for your testimony. Any questions? I have no questions. Anyone from the committee have any questions? Thank you very much. And after your introduction, we will go to Jim Durkin.
Thank you, Mr. Chairman, members of the committee. For the record, Jim Durkin, Legislative Director for AFSCME Council 93. As Bridget said, here to seek your support for Senate Bill 1167. Mr. Chairman, if this sounds familiar, it's because I was before this committee back in June to testify on what was essentially the same legislation. It looks like a change in committee assignments prevented this bill from being heard at that hearing, but we're grateful for the opportunity to restate our support for correcting this long-standing injustice for the workers at the MWRA. What the bill would do was repeal provisions of the 1984 legislation that established the MWRA, provisions that prevent workers from negotiating a process for promotions, and strips workers of a so-called just cause provision in their contract, which protects them from unfair or excessive discipline, including termination. And because repeated attempts to repeal this small section of the law have been unsuccessful, the workers at the MWRA are the only public sector unionized workers in the Commonwealth who do not have these very basic fundamental collective bargaining rights. And unlike the bills heard by the committee back in June, which seek to repeal these two provisions separately, this bill filed by Senator Collins repeals both in one bill. More specifically, the bill would eliminate provisions in the enabling legislation that have given the MWRA unfair management rights regarding discipline procedures and assignment and promotion of workers, a provision that allows the authority to discipline or even fire a worker without sufficient cause, and a provision that relieves the authority of their responsibility to bargain a fair system of assigning and promoting workers. Again, this legislation doesn't give them, these workers, any special rights. All it does is provide them with the same rights afforded to every other public employee in Massachusetts under state collective bargaining laws. Under current law, the MWRA can arbitrarily impose any discipline action they want on any worker, regardless of the alleged offense. The decision is left entirely to the whim of management. And you'd like to think that they don't abuse this right. Unfortunately, I can assure you that's not the case. There's been a number of cases over the years where unfair and unbalanced punishments have been handed down to our members. In some instances, the discipline's extreme. In other instances, workers who commit the same offense and have identical performance records are subject to vastly different discipline actions. Once again, left entirely to management's whims. So the legislation would end this unfair practice. It would require the MWRA to do things like warn employees of probable discipline, conduct an investigation and present evidence of the alleged misconduct, apply work rules consistently and without discrimination, and impose discipline appropriate to the offense. The bill would also repeal a section of the law that prevents our union from being able to negotiate a process for promoting workers, another right afforded to every other union employee in the Commonwealth. Simply requires management to negotiate with the union over these issues. Doesn't require them to agree to anything other than to negotiate. We'd like the opportunity to bargain over the right to apply for a promotion. And without this right, our members are placed in a difficult and unfair situation. We've had experienced, highly qualified, licensed members who have been passed over for promotions in favor of individuals without the proper experience and qualifications. And, I would just close up by saying denying the best qualified people a chance to advance not only hurts the individual workers, but the ratepayers as well, who we believe have a right to be served by experienced, well-trained staff. Finally, Mr. Chairman, in the previous legislation, the separate bill providing workers with a just cause provision received a favorable recommendation. And because there was no cost associated with the bill, it went immediately to steering and policy. That was in March of 2020. And we all know what quite understandably happened with most legislation after that. So since there's no cost associated with this bill in its entirety, it's our hope and request that it follows the same track soon. I thank you for your consideration. I'll do my best to answer any questions you may have.
Thank you very much, Mr. Durkin. I appreciate you bringing a very important topic back up to the attention of this committee. I appreciate Senator Collins for having filed the bill. Senator's a member of the committee and is here with us for this hearing. So thank you for that. It is important. So thank you very much for bringing it to our attention.
My pleasure. Mr. Chairman, I may also be able to shed a little light on some of the questions you had about the pay equity bill. If you have a moment, for one thing, you should be aware that there are other bills filed that went to public safety and homeland security. All these bills have a great noble goal, and we support all of them. We do believe the bills House 2474 and Senate 1587 before Homeland Security are the best approach to doing this. But in a nutshell, here's why there will always be pay inequity if we don't do this legislatively. The negotiation process, it used to be handled by county to county, and some would be able to negotiate higher pay, others wouldn't. But when the state brought all these counties under A&F, they are now subject to the same contract parameters as state employees. So it's, they set out at the beginning of negotiation, it's 2% per year, say. So unless we do something legislatively to close this gap, there will always be this inequity. And I again, thank you for your time.
Thanks for the explanation. I appreciate that. Anybody else from the committee have any questions for this witness? Okay. Thank you, Mr. Durkin. I appreciate it.
Thank you.
Thank you. Next up, we have Edward Wall.
Thank you, Chairman Gordon, and also Chairman Brady when he comes back. My name's Edward Wall. I'm from Somerville, Massachusetts. I'm testifying on behalf of Elders Climate Action, Massachusetts chapter with over 1,000 members in Massachusetts. I'm testifying in support of Bill H4170, an act to mandate the review of climate risk in order to protect public pension beneficiaries.
Mr. Wall, I think you might have gone mute. Take a look.
It's my thumb. The time has come to scrutinize more directly the pension portfolios to eliminate the risk inherent in investments in dirty energy production. The reasons include the following. The risks of such investments are more and more apparent every day. For that, I asked you to look at the several sources footnoted in the written testimony that outline the financial risks in these investments. Second, no public pension beneficiary should continue to be subjected to those risks. Third, taxpayers should not be subjected to the possibility of having to foot the bill for either an inability to meet defined benefit payments or for fund deficiencies, or to make up for reductions of payments in any kind due to fund performance and climate risk investments, nor should the general fund be hit for such deficiencies. These funds should be self-sustaining. Finally, continued investment in the dirty energy business is contrary to our Commonwealth's climate policies. Let's not make it harder to meet those climate goals by conflicting, inconsistent investment policies. A note on what the bill does not ask you as legislators to do. It is not asking you to make a decision on which investments to ban. It delegates that to a climate risk investment committee, a committee of experts. Each investment will be looked at on its own. For example, a methane leak detection company is in the dirty energy business, but is providing tools that can be used to reduce GHG emissions. So that type of company would be looked at differently than other dirty energy companies. Exxon shares have declined in value by 30% in over 5 years, from 91.18 to 64.37 most recently. That's one data point. That doesn't mean you get rid of Exxon. Maybe Exxon is turning around and investing a lot of money in clean energy, but that's the type of scrutiny that this committee will provide. Third, a biofuel company may pelletize mature trees in another state, while another biofuel company may comply with our state's very restrictive regulations on use of wood. So that's a factor that the committee can take into account and apply. This is also not an overnight process. Its implementation is no later than 2025. So the bill really creates a clear financial and policy lens through which to look at climate risk investment categories. That's the focus of the bill. That's the purpose of the bill. Its time has come, and we hope your committee will give it due consideration and ask you to read out this bill favorably. Thank you very much for your time.
Thank you very much for your testimony. I don't have any questions. Any questions from any members of the committee? Okay. Now, thank you very much for your testimony. Right now, I don't see any other witnesses who have signed up to testify. We did just moments ago, get an email that there may be a city councilor who wants to testify. So what I'm going to do is this. I'm going to read off the list of bills that we are hearing today. And publicly, Senator Collins, your hand is up.
Yes, if possible, given that there's some time, I'd love to just say a few words on behalf of my bill.
Absolutely.
11. Okay, great. Thank you. So just thank you for the time, and for those who testified before. This bill before us, Senate Bill 1167, would just be a simple repeal of a small section of the 1984 Enabling Act for the MWRA that blocks bargaining units from negotiating a process for promotions and just cause provisions in their contract, along with which really would prevent unfair, excessive, and imbalanced discipline. So that there, I think, was already brought up. They're the only unionized public employees without these basic fundamental collective bargaining rights. So the legislation was moved last session, as was previously described, and I'd ask that the committee approve it favorably. Thank you.
Thank you, Senator. I appreciate that testimony. Oh, yes, I'm not muted. Anybody from the committee have any questions of our fellow committee member, Senator Collins? Okay, thank you very much, Senator. So I'm going to go back to reading the list of bills that we've heard. We are going to keep these bills open for 7 days, which I calculate to be what, the 23rd at 5 p.m. And we'll close it then so that we can accept further written testimony on these bills. But they will be closed at that point. So bill number 1265. These are the list of bills we've heard today. H1281, H1295, H2554, H2568, H2613, H2619, H2630, H2653, H2669, H2678, H2685, H2694, H2717, H2721, H2722, H2735, H2741, H2781, H3967, H3968, H4040, H4170, H4171, H4206, H4209, H4232, H4233, which is the bill that our city councilor may want to come in on, but he's not here yet. You know what? I think Rep McMurtry has just joined us, so I'm going to interrupt reading off these bills. Rep McMurtry, are you here?
Mr. Chairman, I am. Thank you very much. Good morning.
Good morning.
I appreciate this opportunity, and I'll be brief. I know I'm a little late to the hearing, and I know you have a busy schedule. And I do want to, I feel compelled and certainly obligated as Chair of Veterans and Federal Affairs to testify in support of House 4171. And I know you and members of the committee are familiar with it, but just basically and briefly, currently a member of the armed services who enters into the retirement system has 180 days from the date of them being notified to be able to, given the opportunity to apply for eligible credible service. And oftentimes this notification goes unaddressed by the veteran, who typically is a younger adult and eager to enter into public work. The window of opportunity closes and passes without them allowing them the desirable and opportunity and for serious consideration to be able to make this decision that will impact their life for the years ahead. So what this bill does do, it calls for the elimination of the 180-day window and would justifiably and rightfully allow the veteran to buy back the time that they have deservingly earned at any time throughout their career. And furthermore, it would allow the veteran to take that necessary time to make this important financial decision and adjust their finances rather, in order to make this and the buyback possible. So quickly in closing, if we are a Commonwealth are truly grateful for the less than 1% of the men and women who take an oath to wear the uniform of our country, then we would support them throughout their career, not just for the first 180 days. And I respectfully ask for your favorable consideration of House 4171 in support of the veterans of the Commonwealth.
Thank you very much, Rep. I appreciate your testimony. Any questions from anyone from the committee? Hearing none. Thank you
Mr.
very
Chair,
much. Yes.
Mr. Chair, I would just like to say, Rep. McMurtry has addressed this before, and as have other representatives. I think it's a superb bill, and I hope we move to take this issue off the table for good, report this out favorably, and for all the points that the representative made. It's an excellent point. I have been on the Public Service Committee since, I guess, 2015, and in some form or fashion, this is brought up every session, and every session we fail to address it. So maybe this time we can move this along and, as Representative pointed out, help out these younger veterans, because as he pointed out, when you're a young guy or gal coming back from Afghanistan, you may have a state job. The last thing in your mind that you're thinking of is signing up and making sure that your time in service is counted. That's normally not a big priority in your early 20s or whenever it is you get hired. And I think it really does our veterans a disservice by not allowing them more flexibility. Thank you, and thanks Representative McMurtry for making a case.
Thank you, Representative Cost. Thank you. Okay. Let's see. Seeing no other witnesses who have signed up. If someone has signed up and I just don't see you, let me know. But I'm going to return to calling the list of bills before the committee. And the next bill to be called, in fact, is S1167 that we just heard testimony about. We have S1658, S1689, S1704, S1712, S1743, S1752, S1777, that's 1777, and S1781. Those are the bills we have heard today. Those bills will close 1 week from today at 5 p.m. I don't see anyone else on the line. And so, having heard testimony on all the bills, I will entertain a motion to adjourn.
So moved.
All those in favor say aye.
Aye.
All those opposed? Okay. Motion passes. We are adjourned. Thank you, everyone, for your testimony and your attendance. Thank you, the committee members, for your attendance as well. Thank you.